The broadcast is now starting. All attendees are in listen-only mode.
Okay, welcome everyone to the February edition. Just make sure I'm on have the whole screen here. The February 2018 edition. This one is going to be trumping HR, trumping human resources in 2018. You know, we every year, we're going on almost 6 years of doing the webinar series, and each year try to do, where are we going in 2018? So we're going to do some prognosticating, and then we're going to do a little bit of looking back on 2017, but primarily because what happened in 2017 is going to have an impact on what is going forward in 2018. So, and there's going to be some new stuff in 2018. So anyway, I think there's a lot to discuss here today. So thanks for attending. For those of you who are new to the HR Best Practices webinar series, my name is Kevin Mosher. I'm a partner at the law firm Thompson Co. in the Minnesota office, and a certified specialist in labor and employment law, and I welcome you to the series. If you, when you registered, you should have been given the opportunity to notify if you need HRCI or SHRM credits or any of the CLEs from the various states that we obtain CLEs for. But if you didn't, and if you do need those, definitely reach out to us and let us know. You'll otherwise receive your certificates after in the days after the webinar here. So on the right, there is the opportunity for questions. So you're welcome to write in some questions if you have them, and I will periodically look at those, time permitting, and try to address those unless they were answered already in the series. So in the day. So we've got a lot to talk about today, but I think we'll have some time for questions. It is interesting going through and looking at the what's gone on in the last year. There's been so much press on the change of the the executive branch and the administration. And really, when all was said and done, I mean, there certainly were some changes, but really they kind of came into two camps, as we'll talk about today. They really, mainly in December, we started to see some real changes with labor laws, or decisions on the labor law side. So the National Labor Relations Board starting to overturn and set the expectations for 2018 and beyond during the Trump administration for what's likely to happen with the NLRB and labor, unionizing efforts and that sort of thing. So I think in December we started to see some stuff there. Otherwise, immigration kind of took up a lot of the oxygen in the room. At least on the labor and employment, the HR side of things. Obviously, other issues engulfed this administration and have set a lot of the tone and everything. But on the HR side, I mean, there was a lot of expectation and a lot of, worry or not worry or excitement for what the administration might bring. And in a way, they did a bunch on the HR side to change some HR things. But I think the real impact is likely, if there is going to be a real impact, it's going to be in 2018, 19, and 20 and beyond. It takes a while to get the right people in place at like the EEOC and the National Labor Relations Board, because they're set for they're appointed for a certain duration. So there's always overlap, from one administration to the other. And so it wasn't until just the last couple months that the National Labor Relations Board, for example, really has become a Republican majority. So for most of 2017, it really wasn't. Obama appointees were still in place, and so we're likely to start to really see the changes at the National Labor Relations Board, the impact that they can have. We're likely to see that in the next 4 years, starting just a couple months ago. Similar at the EEOC. And then there really, as far as legislation goes at the federal level, there really hasn't been a lot done. I think, I don't think the administration did a lot last year other than put all of its eggs in kind of the tax code changes. And so, a lot of these laws on the HR side really just didn't materialize. So like the Obama administration, and they didn't materialize really under the Obama administration either. And so that's why the Obama administration and now the Trump administration are looking for change to be effectuated through regulation and through the agency level. So we're going to talk about a lot of that, what happened in 2017, and then what's likely to happen in 2018 on those. And then we are also going to talk about Me Too. Now, last month we did a full webinar on Me Too, but I think it bears, going over it. It's certainly going to have, in my mind, it's certainly going to be impactful on 2018 from a legal standpoint and from an HR standpoint and just a workplace generally standpoint. I think Me Too and Time's Up, those two movements are going to be impactful on the workplace environment generally. And then we'll talk about some other stuff that might come in 2018. It's a little hard. There's not a ton of guidance from Congress. And there's just a little a lot of this is just kind of speculation as to what the Department of Labor might do and what the NLRB might do and what the EOC might do. Like I said, the administration at the top levels, really hasn't articulated much of anything other than to mention paid family leave. It's probably the only real potential legislation that I've seen from this administration. Otherwise, they're looking to do stuff through regulation, like Obama did, because he wasn't able to get Congress to do anything either. So there's kind of a theme, like Congress's inability to actually do anything and make any sort of agreement. So that seems to have not changed from one administration to the other, at least with regard to HR. So back to the future. So we're going to we'll start with the National Labor Relations Board, because that's really where the most change has been. I'm sorry if that bores you. I know a lot of employers, most of you on this call probably don't have unions. That being said, some of the good stuff that's come out of the administration, good in my opinion, has been to clarify that to help out non-union, because one of the themes from the Obama National Labor Relations Board, so during the Obama era, one of the big themes there was this change at the National Labor Relations Board to really not focus as much or exclusively on union environments, and to clarify that the laws, the National Labor Relations Act, could be more broadly understood to include non-union workplaces. So theoretically, that's kind of always been there, where the whole issue of concerted activity, Section 7 of the National Labor Relations Act, concerted activity, what, quote, is concerted activity? And do you really need a union? Now, concerted activity certainly is, two or more employees coming together to try to form a union that would represent them. Now, that's, I think everybody can kind of understand that. But where the Obama administration took this whole issue of concerted activity is to say, no, we are going to help those employees who are coming together for all sorts of purposes regarding terms and conditions of employment. We are going to really focus on those non-union employers and help employees with their assertions of protected activity, concerted protected activity in a non-union environment. So when they're complaining about safety, or if they're complaining about social media policies, or if they're complaining about employee handbooks and statements in employee handbooks, even if there's no union, the National Labor Relations Board has spent a lot of time going after non-union employers. So that's the bad news. The good news is that the Trump administration is likely to continue to erode the Obama NLRB's expansive definition of concerted activity and what's protected under Section 7, and to erode that, take it away, and reinstate this idea that concerted activity isn't as broadly defined, and it is, and the NLRB is likely to focus more on union type of workplaces, which is good for you, most of you on this call that don't have unions. And we should celebrate those of you who don't have unions, because unions are normally not great to have and not wanted by management and HR. So, okay, but let's talk about some of the decisions from the Obama era that basically have been reversed in the last couple, month and a half, by the Trump administration. So we've got one of them is and if you're on the HR hotline program, you should be well versed in this, because we've been doing a lot of tips of the week on these changes. So if you've been reading the HR tips on these, none of this should come as too terribly much of a surprise for you. The micro unit standard. So one of the issues, one of the things that unions have wanted for a long time, is to be able to create tiny bargaining units of employees. Why? Because it's easier to talk just a few people into joining the union. Unions like to, have little pro-union parties and invite people over and, give them cookies and drinks and stuff like that, and say, hey, we really should, this should really come together and unionize, and wouldn't it be great? That was a pretty crappy raise that you got last year. Wouldn't you really rather have a really big raise? And, we can deliver that for you, right? And make all these promises over some drinks and cookies and, crumpets or whatever. And so that's how the unions like to often organize. And it's easier to get a few people to show up at one of these events and to try to get them to unionize, or maybe it's a real pro-union person that's gone from job to job and they're a SALT, or maybe they're not a SALT, but they're just really pro-union. They want to bring in the union. So it's easier to organize a small group of employees. So when we do counter-organizing, often the strategy is that we want to water down that proposed bargaining unit by bringing in people that we believe are not pro-union, and that are more likely to either be swayed against the unionizing effort and vote against the union, or who we know are pretty pro-employer. So we want to normally expand, so that core group of, like, let's call it 5 employees, for example, who are really pro-union. We want to normally, as an employer, strategically expand it beyond that and water those 5 down and bring in 15 or 20 people into the proposed collective bargaining unit, so that we have a better chance of prevailing and getting more than 50% of the, or at least denying the union more than 50% of the vote. So the unions for decades and decades have been pushing for this micro unit concept, where they can say, like, no, just this tiny, like, little group of janitors, like, they work at this one facility, and we want to be able to organize just them. And so they organize just like the 5 of them. And the hopes, of course, for the union is, like, once you get a union in, then it's easier to organize the rest of the employees, other bargaining units. And so the unions have really been pushing this. And so the Obama administration gave them that and started to certify bargaining units, these micro unit bargaining units, and giving the unions what they've been wanting for a long, long time. The National Labor Relations Board, General Counsel, they issued a memo at the end of December overturning that, and basically saying that the micro unit standard is not going to be the one that we look at going forward. Now, as is always the case with the National Labor Relations Board, the reason that it doesn't have a whole lot of in the industry, it's not normally well looked upon, is because it vacillates based on political affiliation all the time. So normally it's whoever's in the executive branch typically gets 3 of the 5 members. And so now you have the Trump administration with 3 of the 5 members, so they have a majority. So if they ever want to overturn these, like, really important standards, they can just, like, say, okay, we're gonna basically put on the people that we know are going to vote against it, to vote and get the votes. And then under the Obama administration, they had, Obama was able to appoint 3 of the 5 members. So the ruling party gets a majority. And so as a result, politics plays a huge thing in this. And so the Trump administration is going to be overturning the micro unit standard, which is great if you don't like unions. Who knows? Next president, if it's a Democrat, could very well put it right back in place. This is what we end up with on the union side. The good news is that for the most part in the private sector, unions are just going away not because of all these laws and stuff and rules necessarily, but really because they have a pretty crappy product to sell. I think for the most part, the private sector is moving away from the concept of unionization because unions don't have as much of a place in the American workforce anymore. Personal opinion, but I think it's borne out by statistics as well and the trends. Totally different in the public sector, but in the private sector, I think unions are going away. The DuPont ruling was overturning that. So another thing the Trump administration did, allowing businesses to change policies without the union's permission if similar action had been taken in the past. So if we have some historic ways of going about doing business, where the company has made changes to the procedures, things that are even impacted by the collective bargaining agreement, the Obama administration had the DuPont ruling that said that no, even if the unions conceded to it, hasn't said anything about it in the past, then in that situation, then you still need to bargain over it. It's still a mandatory subject of bargaining, and you have to bargain over it. And the Trump administration is taking that away, saying no. If the unions conceded to it in the past, either through inaction or this is just the way you've on the ground, this is the way you've implemented the collective bargaining agreement, then in that situation, the National Labor Relations Board now going forward is going to say, no, that's fine. You don't have to bargain over it. The union can't come in later on, way later and say that you failed to bargain with them. We can actually look again at past practice, which is great. Prediction. One of the big things that the Obama administration had done is this Quickie Election. Ultimately, it never really did help the union. I'm sure it did here and there, but ultimately, we haven't seen a huge surge. That was the fear. We haven't seen a huge surge of unionization. Again, I think it's primarily because they don't have a great product to offer to people. But in 2015, it was 2014, took effect 2015, the NLRB changed the timing, the way that they administrated elections. So the way it works on the ground, if you're not familiar, is that a union they'll try to get their, pro-union people, and then they'll try to get a petition going. And they'll have that petition signed, and then they'll bring the petition, and then you have to decide, call it the Excelsior list, or used to call it the Excelsior list, or the voter list now. And you would get the Excelsior list or the voter list, and you would say like, oh, okay, did you get, here's the vote. This is what we're looking. This is the group that we're looking at potentially voting. And then the NLRB would say, okay, give us some dates, and we'll look at it. And they'd issue the dates. And so it used to be 25 days later. And in that 25 days, we would start doing on the employer side counter-organizing. So the union has like as much time as they want to try to organize employees, but on the employer side, if the employer doesn't know that the employees are organizing, which is really bad if you don't know that employees are organizing. If the employer doesn't know, then there's really no counter organizing that can occur. The union's welcome to organize as long as for a while before filing the petition for recognition with the NLRB. And but so they changed it from 25 days to 12 days. So as a result, the average time reduced from 38 days to 23. So that's just not a lot of time for employers who don't realize that the union's organizing. It's not a lot of time for an employer to really do an effective counter-organizing campaign. Sophisticated employers that are, well versed in fighting unions, that's one thing. They not as big of a deal for them. They're probably ready to go and have a lot of materials at the ready. But for a lot of your typical employers, your smaller employers that aren't used to counter-organizing campaigns, it takes them by surprise. And suddenly, before you know it, there's a vote. And the union's all ready for the vote, and the employers are often not all ready, and they don't even know what to say or do, and they don't have lawyers to get ready to counter-organize. So it's a real disadvantage for employers. And so in December, the NLRB asked for comments on this. Now they're going to change it. Let's put it this way: if I have money on this, the money is going to be on the NLRB absolutely reversing this Quickie election thing. I think it's going to be anytime now, soon. It's going to be soon. But so they've asked for comments. Like, okay, great. This administration, just like the Obama administration, it's not all that different. They ask for comments all the time, but do they actually really listen to the comments? So many of the comments are probably Russian bots anyway, or fake comments. They collected a lot of comments from the Department of Labor and looked at the statistics, and a ton of them were, a vast majority were like, fake bot comments. Maybe Russians, who knows? But in any event, so they're collecting comments on this. The comment period just closed this week, and so expect any time between now and the end of the Trump administration, but likely in 2018, sooner rather than later, that the National Labor Relations Board is going to reverse this Quickie election thing, and we're going to go back to a more standard 25 days, maybe even more. Who knows? The longer the better, honestly, for companies. So it could be increased beyond 25 days. But I think we're going to be seeing that pretty soon, since they just closed down the comment period. More protections on the labor law side of things. The National Labor Relations Board is likely to come out with some changes in 2018, maybe 2019. But now that they've got a majority, now that the Trump administration has a majority, that are going to limit, that are going to expand an employer or reinstate an employer, however you want to say it. But they're going to take away the handcuffs that are on employers right now for disciplining employees or firing, whatever you want to do, disciplining and firing employees who are doing certain types of protesting. who are leaving work. We've one of my partners, John Ross, who many of you might know, just won a great decision on this, fighting against protesters at Burger King restaurants. And so one at the National Labor Relations Board, protecting an employer's right to discipline employees who are violating company laws, and who are even though they might be part of a protest group, who are protesting like this $15 minimum, the 15 minimum wage issue that's kind of taking the nation, and has been for several years. Can expect that to continue, that with this National Labor Relations Board, that employers are increasingly able to discipline employees, even though they might be engaged in protected activity on the side, but employers having more and more rights to discipline employees who are legitimately violating company rules. That are legitimate company rules. Expect that the 2014 email system decision, which was quite astounding in my view, when the National Labor Relations Board in 2014 said that in a non-union context, this is all regarding non-unions, in a non-union context, said that no, if you're allowing employees to send emails, like personal emails, asking for Girl Scout cookies, that sort of thing, through an email system, you have to allow them to send emails to try to organize, on behalf of unions, like pro-union types. So an employer is not entirely in charge of its own email system. That's what basically the takeaway from that decision, and that's pretty scary. It's pretty unfortunate. Even if you have in your employee handbook or your usage system of company internet, like your internet usage policy or electronic usage policy, and you have in there that it's your discretion, there's no right of privacy, and you can take away or give to employees the right to use electronic mail and faxes and all that, all the IT system. Well, the NLRB came in and said, no, basically, if you don't really get to put all the parameters on an employee's use. If you're allowing them to use it for non-business purposes, you can't say that you can't use the system not to solicit coworkers to join a union or to join in some other cause that might be considered potentially concerted activity. You can't put a stop on it. You can't limit it. So expect that the NLRB is going to reverse that and give employers a lot of their property back, their discretion back, to have email policies again that are well conceived, and not that they're retaliatory or anything, but that makes sense from a business standpoint to say, yes, we get to be in control of our email system. And so I expect that that's coming back to employers. Thirdly, I think that the NLRB expect that they're going to, whereas the Obama, like I mentioned before, the Obama administration had expanded what is considered to be concerted activity being protected by Section 7. This is the definition of concerted activity: when two or more employees take action for their mutual aid or protection regarding terms and conditions of employment. And so a lot of employees take that to mean like, oh, if I get together with a couple of my coworkers and I want to start protesting $15 minimum wage, or I want to start protesting that we're not getting paid time off, and I start being obnoxious about it, like I can get away, like I'm Teflon, I can get away with all of that. And the Obama administration, NLRB, had certainly expanded the definition and included and given all these employees lots and lots of rights and protections when it was like two or more of them trying to change the terms and change their employment terms. And expect that the Trump administration is going to kind of scale that back and not be as widely defined in what concerted activity is. And I think that'll be a good thing for employers generally, in a non-union situation in particular, because that's where a lot of the focus has been at non-union employers. There are three decisions that are likely to be overturned, kind of with regard to these issues. The fresh and easy decision, again, these were all pretty controversial NLRB decisions during the Obama era board, and I expect that they're going to be overturned, if not this year, then very soon. And so we've got the fresh and easy decision, which is that concerted activity when an employee asks for help. So if in that situation you had an employee who asked a couple other coworkers to try to like catch another person harassing them, and so they asked the coworkers for help, and the NLRB said that that's concerted activity protected. Like you can't, even if you wanted to discipline, because they went, kind of above and beyond to try to, get this sexual harasser, right? And to document this. And so the company decided, like, what they did, or at least the one person, what that person did was violation of other company policies, and so they did something about it. And so the NLRB came in and said, no, that's concerted activity, and if the employee is asking for help trying to document sexual harassment, but it's the asking for help that makes it concerted, then that person's kind of Teflon and you can't fire them. But really you can't fire them for the concerted activity, but you can fire them for other things. So anyway, the Obama decision, era decision on this, on fresh and easy, was certainly controversial. I expect the Trump administration is going to scale this back and limit what exactly this concerted activity protected by Section 7 is. The Sabo decision protected the employee when one coworker came to a bunch of others, their truck delivery people, and said, hey, did you see that Sabo's they posted for a job, and I bet so-and-so is going to get fired, and they started causing all this gossipy trouble at the company, and so they got fired. The ringleader here got fired for gossiping and for causing all this consternation and loss of morale at the place. And so the NLRB came in and said, no, they're talking to other coworkers about this job posting and how they might get fired and who might get fired. That's protected by the National Labor Relations Board Act. And again, non-union, and expect that the Trump board, if they get something along these lines, would reverse this and say, no, you can't. That's not what was contemplated by the National Labor Relations Act, to fire somebody for gossiping and lowering morale. That's not what we're here for. So I expect the Trump administration board is going to reverse that. Then you've got Omni Commercial, and in that one you've got an employee who was just flat out wrong. He thought that he was protected by this collective bargaining agreement. And so he did a bunch of things that he thought were protected by the National Labor Relations Act, and that was just flat out wrong. He wasn't. But the NLRB said, no, it doesn't matter. He's protected. So again, non-union employee thinks that he's doing some stuff in good faith, but he's not. And so the NLRB still said, like, nope, he's still, even though he was wrong, he's still protected because he honestly believed he was doing this under the National Labor Relations Act. And so the NLRB, under the Obama board, protected him. Expect that the Trump administration is going to reverse this and say, no, we don't care about an honest good faith belief. If it's not concerted activity, it's not concerted activity. You don't get protected. So a lot of NLRB stuff is likely coming down the line. Moving on to Me Too, and time's up. So let me see if there are any questions. No. Okay. So moving on to Me Too. And I suspect most of you have probably heard, about this whole Me Too Time's Up thing. Time's Up is as of like January 1. So it's, it was like 2 weeks old when we talked about it last month, and now it's like 6 weeks old. So still pretty new. And the difference is, for those of you who weren't on the webinar last month, the Me Too I think is, pretty clear. It came out of late last summer when you had the Harvey Weinstein stuff, all that crazy sexual predator type stuff and abuse of his employer relationship as a CEO of a movie studio, and then also you've got abuse of authority by several Fox News analysts and executives and personalities there, and all the crazy sexually hostile culture over at Fox News. And so those two combined to kind of create this era right now, if you want to call it, where people are coming forward. Let's just call them women, because for the most part it's women. I know there are outliers, men are coming forward too, but for the most part it's women. So this culture where a lot of women are coming forward to talk about mainly employment relationships. Like, most of these are women who are experiencing really bad, like, sexual harassment that's illegal under federal and most state laws. So that's Me Too, and then that hashtag, and then it went viral on Facebook, and so it's kind of like the Me Too thing. And then Time's Up is something that you saw a lot of at the Golden Globes and then the Oscar ceremony. And Time's Up came from an idea that was posted in an editorial, I think in the New York Times on January 1, saying, and it's the creation of more of an advocacy group that's going to look to change the laws. And so long term, Time's Up actually is kind of the operational implementer. So they're raising a lot of money. They've raised a lot of money. They're going to be doing legislative advocacy, and they're also going to be supporting, or at least the plan is that they're going to be funding lawsuits against employers, in pretty much lawsuits against employers for claimed victims. So that's Time's Up. So long term, if we see lobbying efforts and we see a lot of, I think long term, Time's Up is the one that could have a real impact on legislation, whereas Me Too is more of this cultural phenomena that we're going through right now. But combine them, and I think we still have a lot that we need to train on and talk on. And if you haven't been doing training, if you haven't done training, if you don't have planned training for sexual harassment, you need to. I don't care what size of a company you are. If you're starting to get hurt, there are going to be harassment claims that are more likely to be coming down the pipeline here with the EEOC and with the various state harassment investigations. Maybe a lot of these will go straight to court. But one of the things that you're going to need to show, and that'll help you to defend these lawsuits and these charges of harassment, is to show that you've been doing consistent and worthwhile training. And so if you have not done sexual harassment training in the last year, you should get it on the books and have it done. You can contact me about that. I'm happy to talk to you about it and what it entails. Anybody at Thompson Co. In the Labor and Employment Group can do the same, because we do a lot of this sort of training. Expect also that from these changes that a lot of states are going to start mandating that employers do this training probably every other year. So I expect in the next 5 years that there's just going to be a lot of states that tell employers that they have mandatory. California already does, for example, but there's mandatory management, at least, if not all staff training on harassment in the workplace. You have to be doing that. It's just a defensive, and also it's just a good idea. I mean, I don't know any employers that really like harassment in the workplace, just because it's a, beside the human level of it, it's really bad for morale. It's bad for productivity, and employers lose really good employees because they've experienced or seen harassment in the workplace. It's a killer for productivity, morale, culture. And so for that result, most employers rightly want to stamp it out as much as possible. Training is a huge component of that, but it's not the only thing. There's a lot of other stuff that needs to be done. So just understanding what harassment is, kind of like harassment 101, we've got quid pro quo harassment. So that's this for that. Typically manager demands that, hey, you want something, you want to be promoted, you want this job, you want this raise. Fine, you do this for me of a sexual nature. I will do this for you. I will use my power to give you movie roles, to give you access, to give you to give you a higher salary. That's quid pro quo. I think most people understand that. I think that's why the Harvey Weinstein, the Bill O'Reillys, there are a lot of these situations that have been coming out in the last 5-6 months. That's a lot of that's quid pro quo. You do this for me, you give me a massage, and you will get a better acting job. Okay, so I think people get that. That's not as nuanced as hostile work environment, because in a hostile work environment, now legally, a hostile work environment has to be both subjectively viewed as hostile, harassing, and objectively hostile. Now, a lot of employees, rightly or wrongly, might see their work environment as being hostile, as being sexually offensive, sexually hostile. They might misinterpret things. They might not misinterpret things, but that subjective element, it's hard, right? And so if they come to HR and they say, the person, they put their hand on my shoulder. Well, anything else? Is that just a one-off? Yeah, it's just a one-off, but it's really creeping me out, and I need to take the next week off and see a therapist and everything. It's like, well, you can understand that might be a bad situation, but objectively, does that change the terms? I mean, does that justify taking an entire week off of work and going to see a therapist and maybe requesting that you never work with that person again? It's objectively not enough. So a reasonable person under the same or similar circumstances would not likely look at just a hand on a shoulder, a one-off like that from a coworker, as being so much that it changes the terms and conditions of your employment. That's the objective side of it. Subjectively, yeah, they might very well perceive it that way, and they might not be wrong. I mean, it might have been awkward. It might have been inappropriate. It might not have been right. It's not best practice necessarily to touch coworkers like that on a shoulder. It could be demeaning. It could be even sexual. But objectively, is it enough to be illegal? Probably not. Almost certainly not. There could be some other context that add to the circumstances and everything that's different. But hostile work environment's harder because you've got the employee who truly believes that they were sexually harassed. But objectively, probably not. And there's probably not a whole lot to be done other than to tell the person and, don't put your hand on her shoulder again. Like, she doesn't like it. But do you have to fire him? It's a little over the top. So reasonable person, hostile work environment's much harder. Quid pro quo, much easier to understand. That being said, do you still talk to the guy who put his hand on the shoulder and tell him, hey, don't do that again? Yeah, absolutely. You just say, look, don't do it again. Do you suspend him for a week? I think it's a little much. I probably wouldn't recommend it. I think it's a little over the top. So when we look at, here's a list of things that are more likely to be unlawful harassment. And again, unlawful because it's both objectively and subjectively. Subjective, easy, but it's the objectively harassing, such to the point that it could change the terms and conditions of your job. So stalking, sexual nature type stalking, forced fondling, you force somebody that's exerting your will, that's almost certainly going to be unlawful harassment. Sexual assault, obviously. Attempted sexual assault, objects of a sexual nature in the office, pictures, you've got some other types of objects around. You're showing them off to coworkers. Maybe you're telling a really sexual joke that's incredibly inappropriate or overly sexualized or something like that, and it's offensive to people. I mean, you could see where that could be unlawfully harassing. Communication of a sexual nature, again, telling a joke, telling a story. There normally is a line. I mean, what's much clearer of what's unlawful harassment is touching. So touching, it's like, okay, people get it. You touch in a sexual manner, like hand on shoulder, probably not that big of a deal if it's just a one-off. But hand on shoulder, hand on hand, hand on the lower part of the back. Okay, we're starting to add to the circumstances. Those sorts of touches are it seems like too much. It's more of a sexual nature. Communication about sexual imagery, going to be harassment. Potential policy violations, but not necessarily unlawful harassment, inappropriate looks, unwelcome flirting, inappropriate comments, annoyances, petty slights, inappropriate jokes. Again, there's going to be a line at some point. For some employees, it's hard to tell what that line is. Policy violations, you normally have a much lower bar because you normally, as most employers, they want to create a pretty safe work environment, and you want to have that type of culture and keep the morale up. And so potential policy violation where you do something like because it's an inappropriate look, probably not illegal, not unlawful harassment, but inappropriate look. Yeah. I mean, you could tell the person, like, don't put your hand on her shoulder. Sorry, I just got a question I was looking at. But you would go and talk to the person and take some sort of remedial measure, and to say, hey, look, stop with the elevator eyes, okay? She doesn't like the flirting. Knock it off. It might be innocent to you, but it's just kind of weirding her out. She doesn't like it. Knock it off. If it continues, there are going to be some consequences. Inappropriate comments like, yeah, it was a weird joke. Like, don't, your buddies might like it. Some of the employees might like it, and they might not, care so much. But you knock it off. Don't do it. It's inappropriate. Try to have a little bit more professionalism in the workplace. Somebody just asked. I'm about to. Move on to immigration. But somebody just asked frequency for harassment training once a year. Ideally once a year, at a minimum once every other year. If you're doing harassment training as part of the orientation, then you could probably go every other year with all staff. If you're doing, but managers, I would incorporate some sort of harassment training every year for all managers. So managers, I would do it at least annually. For staff, I would do it at least every other year, and ideally you do something at orientation and then just have an every other year schedule, like every March 1st or something like that, whatever makes sense for you, and then have everybody sign off that they've received it. And there's going to be a lot of overlap, but going through the policy, going through fact scenarios, and generally having this conversation about harassment and discrimination and respect in the workplace is just really highly recommended. It just helps you defend on these things. It really shows that you're a diligent employer, and that can go a long way in defending against charges at the EOC and lawsuits. Switching to immigration. Thank you for the question. Switching to immigration. We've talked about the LRB. We've talked about Me Too. I think those two are going to be huge in 2018. They were already huge to some extent in 2017. Immigration, we'll see. Immigration's already started to have some major impact, certainly on the talk show circuit and all that. The big one with immigration is the Dreamers and the DREAM Act, though there is no DREAM Act. It's just potential prospective legislation, and we'll see. We'll see what happens with the Dreamers. Basically, it's 800,000 people in the United States who are young adults for the most part, who have gone to high school, they've graduated from high school, they've stayed clean. So these are 800,000. This is a lot of people. They've stayed clean. They have not run afoul of the law. And they're called Dreamers. They were brought over illegally into the United States by their parents when they were, kids, when they were young kids. And so they're called Dreamers because it's, I know my family, totally different circumstances, but we moved from Wisconsin to Minnesota, and it kind of felt like it was going into a crazy land because I didn't know anything about Minnesota. And so, little different than going from, South America or Mexico or whatever to the United States. Completely different, actually. But I remember as a kid, I really didn't have a choice in the matter. My dad wanted a new job, and so we moved. And so that's kind of what happened for about 800,000 of these kids most of them came from Mexico with their parents illegally. They're illegal. They've gone to school. Most of them have gone on to college, some sort of level of college, and now they're in their late teens and 20s and early 30s, and they're called dreamers. And we'll see if anything gets done with them. But as of, I think it's March 6th, that's the end of their March 6, 2018. That's the end of their ability to continue to renew their 2-year stays. And so these dreamers are going to, starting March 6, 2018, their work authority, so a lot of them probably work for you and other businesses in the United States, their work authority is going to start to go away. And they are so, at by early March 2020, they'll all be gone, or at least they are supposed to be gone. They'll at least all be illegal. So if you have these dreamers, if they've come on and they've got employment authorization cards, they're right now, like, they can't extend that work authority. So starting March 6th, we're going to start to see a lot of these dreamers, thousands every month, that are working for yours and other businesses in the United States. They're going to lack the ability to get new employment authorization cards, that List A, Section 2 List A documents to establish work authority, and you're not going to be able to legally continue to employ them. There's not going to be any further extensions unless Congress does something about it. And again, I think safe money is always there if you bet against Congress doing something. So not to be completely cynical, but to be partially cynical, that we'll see, I guess. But 800,000, I am sure with all the people on this call, that several dreamers are working in your ranks, and there's not going to be any chance for them to get work authority and to stay legally in the United States unless something changes. The other one that is likely to change is we continue to see an overflow of applications for H-1B visas. April 1st is the H-1B visa application deadline. If you want to be part of the lottery, it's likely to be a lottery again. And so if you need H-1B visas, if you've got current students here who are here on OPT or F-1 visas, you're going to need an H-1B visa. You should be applying for an H-1B visa. It takes time to get that application together. Please reach out to me if you're thinking about this, because starting the process on April 1 is not viable. All the applications will likely be taken within and then some, because it'll go to a lottery within, by April 1st, 2nd, or 3rd. And so H-1B changes, they're also looking, and I would not be surprised if this happens because this has been talked about, is that the Trump administration is looking to change the H-1B visa. Right now, all you need to do is pay somebody a prevailing wage rate, and they're looking at raising that so that really, if you want to be here on an H-1B visa, you need to pay the person at least $95,000 a year. And that's just been talked about. There's nothing on that right now in regulation, but watch out for it. I suspect that's a good way for the Trump administration to limit the number of immigrants coming to the United States or staying in the United States to work. And so, consider that, but we'll see. Right now, we don't have anything. One of the good, it's a good thing and a bad thing. The Trump administration is looking to talk about some new rules with green cards, where they're getting rid of the green card lottery. The good news for employers, if you care about employment-based green cards like I do, is that they're looking at expanding it so that we can bring in more green cards for people who are workers in the United States. Good for me, because I do a lot of green cards for workers, and sometimes the system takes a long, long time. So the Trump administration wants to get rid of the green card lottery, and that's just, bringing anybody, well-educated or not well-educated in the United States, and shift the focus more toward green cards for people who are workers, priority workers in the United States. Good, which is good for businesses because that allows you to bring in, get green cards for your good working employees. The RAISE Act, again, that's the RAISE Act is really looking to favor bringing over U.S. workers. So basically not trying to displace U.S. workers. I expect we're going to start to see changes under this administration on the green card process and on H-1Bs, and that will be focusing on higher paid wages, and it'll be focusing on, if you want to get a visa and you want to get a green card, you're going to have to start paying more for those employees, and you're going to have to probably jump through more hoops to make sure that no U.S. workers can be displaced. Right now, we don't have to promise the government when we apply for an H-1B visa that we've done any recruiting in the United States. We have to do that with the green card, but for the H-1B visa, we don't have to. We don't have to show that we're taking, that the best candidate, the only candidate is this foreign person that we're trying to sponsor. I would not be surprised if we start to have to in the future, where they change the H-1B, that we have to actually do a recruiting process. It'll make it much more expensive for employers. It'll be as expensive along the lines of how expensive green cards are, but that's a way for the administration to weed out people as well. Shifting to paid leave, there's nothing really proposed right now, but Trump did talk about it at the State of the Union. His daughter, Ivanka, has talked about it as well. They want to put together this paid leave, but like a lot of this administration's ideas, they have the idea and then they really say, like, now you states go and do it. And so that's kind of what has been talked about here. I haven't really seen anything substantive from the administration, but at least they're talking about a 6-week paid leave situation that would be paid through the state unemployment program. New York, just effective January 1, New York State did something similar. And they're the only state in the country that does this right now, where they have an insurance-based program. So employers have to go out and procure the insurance for employees, and then if an employee wants the time off, then they have to apply for the benefits, and they get a percentage, just like short-term disability insurance, but it's kind of like mandatory short-term disability insurance. And so anybody who's basically taking off for an FMLA reason in New York can get part of their wages paid for through this insurance program. That's kind of what the Trump administration seems to be proposing: 6 weeks of paid leave, but only for bonding and with adoption and new birth. So it wouldn't be just like New York's all FMLA reasons, basically. The Trump proposal is only limited to parents who have a kid or who adopt. So it wouldn't cover sickness or anything like that. We'll see. Again, betting on Congress to do anything is not a safe bet necessarily, but we'll see. At least there's talk about it, so it's something to have on your radar. One other thing, shifting a little bit to the Department of Labor. The Department of Labor has started to undo a bunch of what the Obama administration had done on the joint employer test. In my estimation, good. The joint employer test was more broadly defined by the Obama administration than other administrations had. So the Trump administration is looking to amend the National Labor Relations Act and the Fair Labor Standards Act. Again, that would take an act of Congress, so we'll see. But the Department of Labor has at least started to talk about reinstating the old ideas of joint employer tests, which would be to make it less likely that two employers would be tied together in fighting against a wage claim. So, employers who directly hire from staffing agencies are often now brought in as, like, the hiring company and the staffing agency are both brought in to handle overtime claims, for example. Even though the hiring company has nothing to do with it, they're brought in as a joint employer oftentimes. And the Trump administration is talking about wanting to Save Local Businesses Act. One example would be the staffing agency would be the one on the hook, not necessarily the hiring employer. Intern Test, undoing some Department of Labor rules on what they consider to be an intern. Previously, it was easier to have an unpaid, and when I say intern, I mean unpaid. It was easier to have an unpaid internship, and then the Obama administration came in and said, no. And for the most part, then I started to advise, except in nonprofit situations, it's pretty tough to have an unpaid intern. And I still think that's pretty good advice, because I still think courts would basically find that most unpaid internships with private businesses are not legitimate. There can be situations certainly where the intern is getting educational credits, and that program's part of like an employer university or employer college program. Certainly then unpaid internships are good, but I think we're going to scale back a little bit of what the Department of Labor was looking at with interns, and I think there's a little bit more wiggle room for private employers and nonprofits to argue that interns do not need to be paid. I still generally advise, though, that if you're a private sector employer, unless you're an absolute outlier in working with a college or university as part of an educational program, that you pay people. I don't care if you call them interns or not. I think they're, for the most part, employees. White collar rule. Thought we were done with this, right? The judge put the kibosh on raising the minimum salary level for white collar exempt employees to claim them as exempt. The judge put the kibosh on raising it to $47,476. The Trump administration is talking about raising it from above $23,660. I would not be surprised if in 2018 or 2019 we see some sort of new salary level that goes beyond $23,660 to something closer to lower 30s, so raising it by about $10,000, or doing some sort of step increase where it raises to like 28,000, and change, and then we step increased until we get eventually to the 40s. I see that coming down the pipeline. I think there's a lot of momentum even at Congress for that. So we're getting a pass right now at the $23,660 for exempt workers, but I do think by the time the Trump administration's done, whether it's 2018 or later, that we are going to have a higher salary level. So one rule that is almost certainly going to be put into place, the comment period just expired a week or so ago, is to undo the tip rule. So the Obama administration said for hospitality workers that requiring a tip pool, if you're doing a tip pool as an employer, as like a restaurant, for example, or a casino, that only front house staff gets to participate in that tip pool. And so your servers, your bussers, your bartenders, and that really sucks for back house staff, for the cooks. So the servers are making like tons and tons of money, and then assistant managers are making less money oftentimes than servers are. And your cooks and washers, people who are also part of that, they're not making nearly the money that the front house staff is. And so 2018, almost certainly we are going to see, I would put money on this one. We are going to see the Department of Labor undo that rule and allow restaurants, other hospitality companies to require tip pools, and have the tip pools also include anybody. So it could include assistant managers. It could include back house staff as well. And so you're going to have winners and losers in that one. There's a lot of fight from the servers and everything, but I think it certainly will help cooks and assistant managers in the future. And our time is exactly done. So thank you for participating this month. Really appreciate your attendance. We are tape recording. This has been tape recorded. So for those of you who are on the HR Hotline program, or the myHRgenius, as we're rebranding it, program, you're welcome to go to the website. And if you don't have your login, just let me know. But you're welcome to go to the website and watch this at any time. If you do have any other questions, you're welcome to reach out to me directly on email or by phone, and I really appreciate it. And next month, we will have another exciting HR topic, and I will talk to you then. Thank you.